Hello, my name's Amanda Lennon and I'm a partner in Spencer West's employment law team. We provide the full range of employment law advice, including advising clients of all sizes on day-to-day employment law and HR issues, contract issues, business reorganisations and restructuring, such as redundancies, discrimination matters, data protection, union and employee relations, and TUPE and business transfers. We support businesses and employees with exit strategies and the negotiation and drafting of settlement agreements. We advise on and conduct employment tribunal claims for both employers and employees, and we have a lot of experience as a team in devising and delivering in-house training for your managers and executives. We work closely with our corporate and commercial team to provide employment law advice in the context of business transactions such as share sales, asset transfers, mergers and acquisitions. And that work also includes undertaking due diligence for clients and drafting the employment aspects of the terms and conditions between the parties. In terms of my own experience, I'm both a practicing employment lawyer and HR consultant, which means I get the best of both worlds. And I find that employment law and HR complement each other very well. It also means that I've gained significant commercial experience working in-house, advising and sitting on boards, and delivering employment law and HR solutions in a very practical way on the ground. This update tells you what you need to know in terms of the changes the government is making to employment law in the UK from April 2024. First up is paternity leave. Fathers can take 2 weeks paternity leave following the birth or adoption of their child. Currently, that leave can only be taken in one continuous block of either 1 or 2 weeks, so the father has to choose whether they're going to take 1 or 2 weeks. The change coming in from the 6th of April means that 2 weeks paternity leave can be taken together or in separate blocks of 1 week at different times. The second change coming in is that paternity leave can be taken in the child's first year after birth or adoption, whereas currently it has to be taken within the first 8 weeks after birth or adoption. So good news for those wanting to take paternity leave. Next up is a new right to carers leave coming in on the 6th of April, which we haven't had to date. This gives employees 1 week's leave in every 12-month period to care for a dependent who has a long-term care need. This leave can be taken in full days, half days or blocks. Long-term care need does have a definition, and this means somebody with a disability, a physical or mental illness or injury that requires care for at least 3 months, or care because of someone's old age. The dependent doesn't have to be a family member, it can be anyone who relies on the employee for care. So that can be your spouse, your civil partner, your child or your parent, someone who lives in the same household as you but is not your tenant, lodger, boarder or an employee, and anyone else who reasonably relies on you for care. And so that could include an elderly neighbour that you have caring responsibilities for. Carers leave is a day one right, which is good news. And that means that if you join a new company, you don't have to wait for a certain period to accrue continuous service before you can invoke that right. That right applies from your first day of employment. Another point to note is that carers leave is unpaid, and there will be employers out there who decide to pay that leave, but the statutory minimum is that it's unpaid. Thirdly, there are some key changes coming in to the law on flexible working from the 6th of April. Currently, in order to apply for flexible working, the employee needs to have at least 26 weeks continuous service. But from the 6th of April, that becomes a day one right. So that means there is no minimum period of service needed before you can apply for flexible working. There are a number of pieces of information that the employee has to include in their letter applying for flexible working. And one of those is explaining what the effect of their proposed change is on the employer or how the employer could deal with that. The law changes this from the 6th of April. So from that date, employees won't have to explain what effect their proposed change has on the employer or how the employer could manage that. That will be for the employer to determine themselves. The law is also changing so that employees will be able to make 2 requests in any 12-month period instead of 1. The employer can't refuse the request unless it has consulted the employee first, which is also a change, and the employer has to decide on the request within 2 months unless it agrees a longer period with the employee. So that's a reduction from 3 months currently.
Let's talk about enhanced redundancy protection. From the 6th of April 2024, the Protection from Redundancy, Pregnancy and Family Leave Act 2023 will come into force, providing enhanced protection from redundancy for new or expectant parents. Whilst pregnancy and maternity are protected characteristics under the Equality Act, this hasn't stopped discrimination from taking place. Many expectant or new mothers have reported discriminatory behaviour from their employers, whether it be their negative attitude to the news, a reluctance to promote, perhaps hesitancy when it comes to delegating work, or a refusal to make reasonable adjustments. Currently, parents on maternity, adoption, or shared parental leave are protected from redundancy during the period of their leave. Then, if a redundancy situation arises, a suitable alternative job must be offered if one is available. However, the new enhanced protection extends the priority status to pregnant employees and those who have recently returned from maternity, adoption leave, and shared parental leave. This enhanced protection now commences at the point where the expectant mother tells her employer that she is pregnant and ends 18 months from the child's date of birth. This new legislation doesn't stop an employer from making the expectant mother redundant, but what it does do is insist that the employers prioritise finding suitable alternative employment for them, essentially giving them priority status for redeployment opportunities in a redundancy situation. In the event of a miscarriage, the protected window is 2 weeks after the pregnancy if it was less than 24 weeks, or for the entire statutory maternity leave period if longer. New and expectant parents will be able to double their period of redundancy protection to a period of about 2 years. So any employers contemplating a potential reorganisation of their business need to ensure that they've thought through the implications of this new protection and considered and preempted possible outcomes. Whilst this new protection is likely to be a headache for employers, expectant mothers, those on maternity leave, adoption leave, or shared parental leave will feel a huge weight off their shoulders, knowing that their jobs have priority status. Employers should bear in mind that a failure to offer a priority employee a suitable alternative vacancy would mean the employee has a claim for automatic unfair dismissal and potentially also discrimination. When calculating statutory redundancy, it's imperative that you know the current maximum statutory pay rate, which changes each year. The limit on a week's pay is currently £643 a week, but as of the 6th of April 2024, this is increasing to £700 per week. For those not eligible for an enhanced redundancy payment, the maximum statutory redundancy pay is now increasing to £21,000. Moving on to increased compensation limits for Employment Tribunal claims. As of the 6th of April 2024, the maximum compensatory award for unfair dismissal is 1 year's salary or £115,115, whichever is the lowest. A compensatory award is the second element of compensation that an employee can receive if they are found to have been unfairly dismissed by an employment tribunal. Along with the basic award, the compensatory award aims to provide financial redress for the actual money lost as a result of losing one's job. A compensatory award includes factors such as lost earnings, benefits, and other financial losses, and will now be capped at either 1 year's salary or £115,115. Let's discuss the Vento guidelines. In the leading case of Vento versus the Chief Constable of West Yorkshire Police, which was in 2003, the Court of Appeal set clear guidelines for the amount of compensation to be given for injured feelings. It set out 3 bands as potential awards, ranging from £1,200 all the way up to £58,700. So in the lower band, it goes up to £11,700, and that's for less serious cases, isolated events, one-off acts of discrimination. The middle band is from £11,700 to £35,200 for serious cases which do not merit an award in the top band. And then you've got the top band, which is £35,500 up to £58,700 for the most serious cases, such where there has been a lengthy campaign of harassment. The top band will only be exceeded in the most exceptional of cases. These figures are increased annually each April in line with inflation by way of updated guidance from the joint presidents of employment tribunals. Let's look at the Vento guidelines. In the leading case of Vento versus the Chief Constable of West Yorkshire Police, which was in 2003, the Court of Appeal set clear guidelines for the amount of compensation to be given for injured feelings. It set out 3 bands as potential awards, ranging from £1,200 all the way up to £58,700. The lower band, up to £11,700, is for less serious cases, such as an isolated or one-off act of discrimination. The middle band is from £11,700 all the way up to £35,200 for serious cases which do not merit an award in the top band. Then you've got the top band, £35,500 all the way up to £58,700. That's for the most serious cases, such as where there's been a lengthy campaign of harassment. The top band will only be exceeded in the most exceptional of cases. These figures are increased annually each April in line with inflation by way of updated guidance from the joint presidents of employment tribunals. Let's look at increases in statutory rates of pay, again from the 6th of April 2024. We've got maternity pay, paternity pay, adoption pay, shared parental leave pay. All of those now increase to £184.03 per week, or 90% of the employee's average weekly earnings, whichever is lower. We also have sick pay, which now increases to £116.75 per week.
The government is implementing the most significant increase that we've ever seen to the national minimum wage from the 1st of April, which is great news for workers. The current and new rates that apply from the 1st of April appear on the screen now. The government has decided that any worker aged 21 and over should receive at least the national living wage, and currently this only applies to workers aged 23 and above. For apprentices, the apprentice rate applies if they're aged under 19 or if they are over the age of 19 and in the first year of their apprenticeship. However, if they are over 19 and have already completed the first year of their apprenticeship, they are entitled to the national minimum wage, which, as you can see, is slightly more than the apprentice wage. It's important to note that this is separate to the London living wage, which many employers offer already, and which, particularly if you work in a unionised environment, the unions are very keen on, which is £13.15 per hour. So employers can choose to pay this, but they're not obliged to. And the idea behind that is to help with London living costs for London-based employees.
Let's finish things off by looking at some recent cases. First up, there's a sex discrimination case. This is the case of Asha Ladd versus Lily Head Dental Practice Sales about a WhatsApp group. Now, new mother Asha Ladd sued her dental firm employers for pregnancy discrimination after a male senior colleague refused to let her back into a work WhatsApp group whilst she was on maternity leave. He insisted that there was no reason for her to have access to that WhatsApp group while she was off. However, the Employment Tribunal ruled that removing female staff from work WhatsApp group chats whilst they are on maternity leave is discrimination. Now let's move on to another case. This is the case of Peter Marsh versus Manchester University NHS Foundation Trust, involving a male colleague being told to man up. The recent case of Mr. Marsh versus Manchester University NHS Trust made headlines when it was held by an employment tribunal that a male employee had been discriminated against because of his sex when a female manager told him to man up in front of other female colleagues. This case is a really interesting example of a male employee bringing a claim of sex discrimination based on treatment received from female co-workers. As we can see, typically it's female co-workers bringing cases of sex discrimination. Moving on to a case involving age discrimination. This is the case of Eileen Jolly versus the Royal NHS Trust. This was all to do with her being dismissed because she was too old. Eileen Jolly was dismissed from the NHS Trust in 2017 when she was 86 years old after she failed to upload details of cancer patients awaiting non-urgent breast reconstruction surgery into a new database. This meant that some patients had to wait more than a year for their surgery, which is of course a breach of NHS guidelines. Eileen Jolly, who had been employed at the hospital since 1991, claimed that she had not been properly trained to use the new system, which obviously led to mistakes being made. In a hearing before the Reading Employment Tribunal, she claimed that the NHS Trust decision to dismiss her was based solely on her age and said that there had been unpleasant remarks made about her age and health, specifically questioning her ability to walk the length of the building and questioning her frailty. The Employment Tribunal decided that the former medical secretary was unfairly dismissed from her post at Royal Berkshire Hospital, and she was in fact entitled to £200,000 in compensation. Last case, let's look at flexible working requests. And this is the case of Wilson versus the FCA, involving a request to continue working from home even though the pandemic is long gone. Miss Wilson was a senior manager at the Financial Conduct Authority. She directly managed, I believe, 4 employees and indirectly managed a further 10. In December 2022, she submitted a flexible working request. She'd already been working remotely since the start of the pandemic in early 2020, but following the FCA's implementation of a policy which required staff to split their working time 60-40 between home and office, she requested a formal change to her employment terms to enable her to work entirely remotely. The FCA rejected her request because of the negative impact her requested working arrangement would have on her team. The Employment Tribunal found that the employee's request to work permanently from home was justifiably rejected by her employer, despite the fact that she had been successfully working from home since the start of the pandemic. If you would like a PDF copy of our employment update outlining key facts and figures for 2024 to 2025, then please do email either Amanda or myself. Bye for now.